in doing.
Right. All right. How about retirement benefits?
Well, retirement benefits are also one of those exempt assets, and so that's one of the mistakes that I've seen people make is when they're ready to go into a skilled nursing facility, they start paying with their retirement benefits. That's not something you want to do.
Okay.
Because you don't have to deplete them.
Mm-hmm.
But what you do have to do is you have to draw on them.
Mm-hmm.
And if you're under 71 and a half, you don't have to draw very much. Just enough to make it income. And that income then will be what you'll have to pay to the state, to the nursing home.
Mm-hmm.
But it's a lot less than drawing down your entire retirement benefits.
Yeah. So there's no required minimum distributions for most plans until you're age 70 and a half.
Right.
And so, but what you're saying is that even if you're not 70 and a half, there is going to be some minimal requirement.
We've been drawing as low as $10 a month, $15 a month, just enough
a little something
to be an in-plan distribution.
I see.
If you're younger, of course, you're going to have interest on that, but unlikely that you're going to have an income tax consequence.
You start drawing before 59 and a half, and then you have to sort of annuitize. But you can even do planning. You can split accounts.
Right. So those are the planning issues, but you have to be aware that there are things that you want to do.
Okay. So what are some of the other assets that you can retain?
Well, certainly a car,
Okay.
and you can one car. Business property, if it's income producing, you can retain. There's a formula for retaining a portion of other real property. You can retain anything that has no value. So let's say you have a rental home, and Medi-CAL, for purposes of determining value in real property, uses what's called the assessed value, that value that the tax collector says this is what you're going to be paying your taxes on. Mm-hmm. So let's say you have a rental that's assessed at, you bought it a long time ago, it's maybe assessed at $200,000. Maybe it's now $400,000 of fair market value. Mm-hmm. However, you decide to borrow against it, or you have borrowed against it, and you have a mortgage on it of $190,000.
Okay.
Then the value of that rental now is only $10,000.
So you're counting from the assessed value.
From the assessed value.
And then you subtract the debt.
The debt.
Uh-huh.
So your value then is very small, and that's easy to convert, to change, to exempt.
Okay.
Maybe you borrow a little more, maybe you give a little bit away in small chunks. And,
okay. So what do you do to qualify for Medi-CAL if your assets exceed these various limits or whatever?
Well, that's also really interesting because there's so many things you can do, and that's part of the reason why you really want to see somebody. If you have a spouse or a domestic partner who remains at the home, you may be able to increase that $113,000, $114,000 that the at-home spouse, at-home person is allowed to keep based on need. You may be able to convert cash to exempt assets. Let's say you have a mortgage on your house and you have a lot of liquidity. You can pay off the mortgage. Now all that liquidity is an exempt asset.
So you have a big savings account. You could use it to pay down the mortgage.
You can repair the home.
Yeah.
You can. So there's lots of things you can do you can gift property, though you have to be very careful with gifting. Again, what you're doing is you're making yourself appear destitute by having everything involved in invested in an exempt asset or given away to some person or somehow that it may be used for you in the future.
Okay. What if you have a disabled child? Is there some special planning that needs to be done?
Well, certainly when you have a disabled child, you want to make sure that whatever planning you want to do, you do first and foremost before Medicaid planning, Medi-CAL planning. But having a disabled child brings certain exemptions. One is you can set up a trust for a disabled child, and that's not a transfer that causes any penalties, because when you do give away money as a Medi-CAL applicant in preparation, you can be penalized and you may have to pay privately for a period of time. If you have a disabled child and you set up a trust for that disabled child, there's no penalty. It also, if you're survived by a disabled child, there's no recovery, none whatsoever. It goes away. That's in California. So those are two things that happen, major consequences of having a child who is disabled.
Now, you may have to do Medi-CAL planning for the child too, right?
Well, certainly one of the considerations if you have a disabled child, I would encourage them to make sure that in their own plan, before there's any disability, they've set up some sort of special needs trust or some system to protect the resources that the disabled child will eventually inherit or receive, so that those assets won't become available for paying for their care when public benefits like Medi-CAL or SSI are available to support the child.
Okay.
So yes, special needs trusts are a very good idea for anybody with a disabled child beyond your own Medi-CAL planning.
Okay. Is there any significance for the order of death of the spouses? Like, what if the spouse who lives in the home dies first?
Well, that's a very interesting situation, and if you haven't done planning, can undo all the planning that you've done. If a spouse at home with community property dies before the Medi-CAL beneficiary, then without a will, without a trust, and all the assets pass back to the Medi-CAL beneficiary, all your planning is undone and they'll have to use those assets. So the spouse at home really should have a good estate plan set up. In particular, if they want to have a special needs trust for their spouse, domestic partner, who's in the skilled nursing facility, they would have to do that under a will, at least create the trust under a will and fund it by many different mechanisms. But that's one thing you would want to do, is have some protection for the applicant who's in the spouse or domestic partner who's living in the skilled nursing facility.
Okay. So let's say you are on Medi-CAL. Is there like a certain amount you're supposed to contribute each month for your...
Well, there is, and it's called your share of cost. And your share of cost is generally the amount of income the Medi-CAL applicant receives in the Medi-CAL applicant's own name. So it doesn't consider the income of the spouse or domestic partner at home. From that amount, there are certain deductions that you can take. $35 a month for personal allowance, insurance proceeds, any court-ordered payments. Again, there's another deduction if a domestic partner or spouse at home doesn't have enough money. Then you're allowed to give the spouse at home an income, a minimum income of $2,841 per month, $2,841. The rest goes to the skilled nursing facility, and Medi-CAL will pay the balance.
Okay. Now, you've mentioned something around this, but in some cases these benefits have to be repaid. How does it work?
You'll get a bill from the Department of Health Services if, in fact, you have resources, or the Medi-CAL beneficiary had resources at the time of his or her death. You'll deduct some costs of administration, funeral, etc., and then you'll have to write a check to the state of California unless there is a disabled child, there's a minor child. If there's a spouse living, a surviving spouse, you don't have to pay those back immediately.
Okay.
So there's some exceptions to the repayment.
Okay. So we're pretty close to being out of time. Maybe you'd like to throw out some final thoughts. It looks like we got about 2 minutes here. So.
Well, the idea that you have to be destitute, I want to dispel that idea. The words are true, but the concept is not, because there are lots of ways to retain assets and protect those assets. And planning is important, very important, to have those documents in place, and an estate planner who understands Medi-CAL can do that for you without actually going ahead and transferring the assets. Those are the things that I think are critical to be in anybody's estate plan. And if you anticipate this as a potential need, then get to an attorney who understands this, so your documents can be in place and it's not as big a crisis should the time ever come. And it may never come.
Yes, let's hope.
Yes.
Okay. Well, Jan, I want to thank you for joining me.
Well, my
being
pleasure.
here as my guest.
My pleasure.
And you know, I think that this is very valuable for people to think about, because, well, for one thing, because there's a lot of rumors that go around. You know, it's the bridge club, the hairdresser, whatever. Of course, that's where we always get our legal advice, right? And so, anyway, so to hear it from somebody like you that is dealing with these issues all the time is really valuable. And like I said, it's a good starting place for a conversation with another attorney.
Just don't be afraid to look for that.
Yeah.
And anticipate it and get information about it, accurate information.
Yes. Folks, thank you very much for joining us. We'll see you next time on Financial Insider Weekly.
Thank you.